Tonight, we begin with a sequence of events so precise they defy the chaos of the political cycle. This morning at exactly 10:03 a.m., the heavy bronze doors of the Supreme Court did more than just open. They signaled the end of a legal era. In a brief 16-page order, the High Court issued a 9-0 unanimous rejection of the emergency appeal for absolute immunity. This is not speculation. This is the moment the highest legal authority in this land decided that the shield of the presidency is not a cloak of invisibility, but the real tremors weren't felt at the court. They were felt blocks away at a secure facility. At 10:14 a.m., just 11 minutes after the ruling, a motorcade carrying the former First Lady arrived at an undisclosed federal building. She was there to sign what is legally known as a Profer Agreement. In simple terms, that means she entered a Queen for a Day session, a formal negotiation where a witness provides a preview of their testimony to federal prosecutors. By 12:42 p.m., the atmosphere in Washington shifted from tension to pure clinical shock. Sources close to the special counsel confirm that the spousal privilege, the legal rule that usually prevents a wife from testifying against her husband, was effectively bypassed. This occurred under the crime fraud exception. In simple terms, that means the law no longer protects the privacy of a marriage when the communications within that marriage are used to facilitate a crime. The timing suggests they were closely connected. The court cleared the path at 10:03. The inner circle began to speak at 10:14. The unavoidable facts are now moving faster than the defense can pivot. The legal fortress has been dismantled. Let me read directly from the filing. The Supreme Court's summary order did more than deny a motion. It executed a clinical strike on the very concept of the imperial presidency. By a 9-0 unanimous margin, the justices ruled that the conduct alleged in the superseding indictment falls entirely outside the perimeter of official acts. This is where it becomes legally official. The defense had relied on a theory of absolute immunity, arguing that a president is effectively untouchable for any action taken while in office. The court has now categorized this as a legal fantasy. In simple terms, that means the president's desk is no longer a sanctuary for private conspiracies. The immediate result was the denial of the emergency appeal. When the Chief Justice handed down the decision, he effectively signaled to the lower courts that the trial must proceed without further delay. We are now seeing the activation of use immunity for several key witnesses. In simple terms, that means the government has guaranteed these individuals they won't be prosecuted for what they say, provided they tell the absolute truth about the former president's actions. This is not speculation. The shield is gone, and in its place is a vacuum that the special counsel is filling with high-level cooperation. The court has made it clear the law is not a suggestion, and the presidency is not a suit of armor. While the legal world watched the court, the real history was being made in a sterile room in downtown D.C. At 10:14 a.m., less than 15 minutes after the immunity shield collapsed, the former First Lady arrived for what is formally documented as a Profer session. To the uninitiated, it looked like a standard meeting. To the Department of Justice, it was a seismic event. This is where it becomes legally official. Melania Trump signed a Profer Agreement. In simple terms, that means she entered into a limited immunity window. She agreed to tell the truth about specific events in exchange for the government's promise not to use her own words to prosecute her. It is a calculated leap of faith that suggests the spousal privilege she once relied on has been completely compromised. Let me read directly from the procedural filing. The special counsel moved to bypass the usual protections of marriage under the crime fraud exception. In simple terms, that means if the government can show that a conversation between husband and wife was used to help plan or hide a crime, the sanctity of marriage no longer exists in the eyes of the court. This is not speculation. Our sources confirm the session lasted over 4 hours and focused on the Category 1 evidence, the financials. The former First Lady wasn't just a witness, she was a participant in a clinical breakdown of the family's most guarded secrets. The timing suggests they were closely connected. The moment the Supreme Court said no to the president, the First Lady said yes to the prosecutors. The paper trail has finally found its voice. This is not speculation. While the immunity ruling dominated the headlines, the most devastating evidence was quietly changing hands. The Category 1 disclosure centers on a massive volume of bank records, specifically a series of international wire transfers that current court filings identify as the vault ledger. In simple terms, that means we are looking at a shadow accounting system designed to keep foreign capital off the official White House disclosure forms. Let me read directly from the filing. The special counsel alleges that between 2024 and early 2026, millions of dollars moved through offshore entities linked to the Project Vault Mineral Initiative. These funds were categorized as consulting fees, but the superseding indictment paints a different picture. In simple terms, that means the government believes these weren't fees at all. They were payments for executive influence, channeled through private accounts to avoid the scrutiny of the Ethics in Government Act. The timing suggests they were closely connected. At the very moment the Supreme Court was weighing the former president's immunity, these financial records were being validated in that secret Profer session. The former First Lady reportedly provided the decryption keys, and metaphorically and literally, to accounts the special counsel had been tracking for months. This is where it becomes legally official. With the financial shield down, the flow of money is no longer a mystery. It is a map, and as any veteran investigator will tell you, the map always leads to the motive. The digital fingerprints have been lifted. Let me read directly from the filing. In the world of high-stakes espionage and executive misconduct, it is rarely the face-to-face meeting that provides the smoking gun. It is the data left behind. The Category 2 evidence focuses on a series of encrypted messaging logs known internally as the Dear G files. In simple terms, that means we are looking at thousands of messages sent through back-channel applications, specifically bypassing the Presidential Records Act. This is where it becomes legally official. The special counsel has secured use immunity for the digital forensic specialists who recovered these logs. The messages allegedly showed direct coordination between the West Wing and offshore entities during the height of the mineral initiative. The timing suggests they were closely connected. As the administration pushed specific foreign policies, the private messages were coordinating the financial harvest. This is not speculation. Unlike a public tweet or a press release, these communications were intended to be permanent ghosts. However, the Supreme Court's 9-0 unanimous ruling on private conduct has stripped these messages of any official act protection. In simple terms, that means because these chats were used to facilitate private gain rather than public service, the former president cannot claim they are executive secrets. The logs provide the connective tissue between the money we discussed in Category 1 and the intent behind the actions. We are no longer guessing what was said behind closed doors. The court now has the transcript of the conspiracy. The weight of this case no longer rests on a single voice. This is not speculation. In the lexicon of federal prosecution, corroboration is the process of building a structural web where every strand reinforces the other. In simple terms, that means one person's story is a claim, but two independent sources and a digital trail form a trap. Let me read directly from the filing. The special counsel's latest memorandum details how the testimony provided in today's Profer session aligns with the existing evidence from the Arctic frost investigation. Specifically, the former First Lady's account of the December 2024 vault meetings mirrors the encrypted logs we discussed in Category 2. The timing suggests they were closely connected. The dates she provided for the secret arrivals of foreign delegates matched down to the minute the geolocation data seized from the Dear G devices. This is where it becomes legally official. Under federal law, for a superseding indictment to hold, the new evidence must provide independent support for the charges. By bringing in a witness from the very heart of the family, the government has achieved the ultimate corroboration. In simple terms, that means the special counsel isn't just saying a crime happened. They are showing that the people closest to the president saw it, logged it, and are now confirming it under oath. The unavoidable fact is that the defense of he said, she said has vanished. It is now she said, and the records prove it. The most intimate defense in the American legal system has just been shattered. For years, the public has asked, can a wife be forced to testify against her husband? Under normal circumstances, the answer is no, protected by spousal privilege. But today, we learned that the special counsel successfully invoked the crime-fraud exception. In simple terms, that means the law does not recognize the sanctity of a marriage when the bedroom is used as a boardroom for criminal activity. Let me read directly from the filing. The government argued, and the court agreed, that the former First Lady was not merely a passive observer of her husband's actions. By participating in the Project Vault meetings and facilitating the Dear G communications, she became what the law calls a co-conspirator. This is where it becomes legally official. Once a spouse participates in the alleged crime, the privilege is nullified. This is not speculation. This breach is what allowed the 10:14 a.m. meeting to occur. The defense attempted an emergency appeal to block her testimony, but after the Supreme Court's 9-0 unanimous ruling, that effort died in the water. The timing suggests they were closely connected. The moment the court ruled that private conduct is fair game, the private conversations of the first couple became public evidence. In simple terms, that means the ultimate sanctuary has been invaded. The one person the former president trusted to stay silent has been legally compelled and incentivized to speak. The clinical conclusion is now unavoidable. This is not speculation. Tonight, the former president stands at the center of a perfect legal storm. With the Supreme Court's 9-0 unanimous rejection of his immunity shield, the imperial presidency has been replaced by a superseding indictment that carries the weight of total criminal exposure. In simple terms, that means the special counsel is no longer knocking on the door. They have breached the hull. Let me read directly from the filing. The integration of Category 1 financials, Category 2 communications, and the Category 3 corroboration from the former First Lady has created a triangulated proof. The government is moving for an expedited trial date, citing the extraordinary public interest and the newly secured evidence that bypasses every previous delay tactic. The timing suggests they were closely connected. The court's ruling at 10:03 a.m. provided the legal permission, and the First Lady's 10:14 a.m. meeting provided the factual ammunition. This is where it becomes legally official. The path to a verdict is now clear of constitutional hurdles. We are looking at a future where a sitting or former president faces the cold reality of a federal jury without the protection of the Oval Office. In simple terms, that means the unavoidable fact has arrived. In this country, the law does not stop at the White House gates. The silence you hear from the defense tonight is the sound of a strategy that has finally run out of room.